Are watching News Centre. I'm Parikshit Luthra. The Supreme Court has held that grounds of arrest must be given to an accused in writing without exception. The Apex Court made these comments while granting bail to directors of Gurugram-based real estate company M3M in a money laundering matter. In a stinging judgment, the Apex Court said that only reading grounds of arrest and not furnishing them in writing reeks of arbitrariness. The bench said that the chronology of events speaks volumes and reflects rather poorly, if not negatively, on the Enforcement Directorate's style of functioning. This judgment was in response to a plea by Pankaj Bansal and Basant Bansal of the M3M group. The court said that the safeguards in CRPC and PMLA must be complied with. The safeguards include recording grounds of arrest, followed by serving them on the arrestee in writing. The court noted that not recording reasons and not giving them in writing to accused would entitle the arrestee to be released. Second important issue, the court also noted the manner in which the Enforcement Directorate registered a second ECIR immediately after the appellants secured bail in the first. The appellants were summoned on one pretext and arrested on another within a span of 24 hours, and this approach, according to court, manifests a complete lack of bona fide. To take this discussion forward, we are joined by H.P. Ranina, senior corporate lawyer, and Fareed Karachiwala, a partner of dispute resolution at J. Sagar Associates. Mr. Ranina, if I were to ask you, how do you think this judgment, which will have widespread ramifications, will impact the working of the Enforcement Directorate?
Thank you, Parikshit, for having me on the show. I think the Supreme Court, under the present Chief Justice, is very keen on protecting the rights of citizens. Time and again, they have informed the authorities that you have to be fair, objective, give an opportunity of being heard, and give your reasons in writing. Because only when you give your reasons in writing that accused can defend himself. If you just give a oral statement that give reasons orally, then obviously you can't defend yourself. So giving it in writing is very essential. It is laid down in the Criminal Procedure Code, also under the Prevention of Money Laundering Act, and therefore this has to be strictly complied with. So what the Supreme Court has done is simply to uphold the law and to ensure that the rights of the citizens are protected.
Right. Fareed Karachiwala, the Bansals of the M3M group had taken this plea to the Supreme Court, and the Supreme Court ruled that the protections under 167 CRPC and Section 19 of PMLA, which relate to recording of the reasons for arrest and then furnishing them to the accused in writing, are essential. And without that, the arrestee can seek release, and he can be released on those grounds. Do you think this could give many people who are facing Enforcement Directorate investigations a chance to go to court? There may be more cases like this?
Absolutely right. I think the Supreme Court has given a path-breaking judgment because what was happening in the country is that although under Section 19, it was important for the arresting officer to communicate the reasons, but those reasons were not necessarily given in writing. So we had a situation where in some cases, they were being made to read out the grounds of arrest. In other cases, they were being told the grounds of arrest. In some cases, they were being given copies of the ground of arrest, but the ED was not following a uniform practice in the entire country, which led to the Supreme Court to pass this path-breaking judgment to say that it is not sufficient for the Enforcement Directorate or the officer or the arresting person to actually only communicate orally or make the person read the grounds, because he may not be in a state in order to comprehend the gravity of the offenses, and it would not be fair, because what is required is that the person who's arrested has to be produced before the magistrate, and thereafter he has to basically prove himself that he is not guilty of the offense, and the magistrate has to be convinced, based on the plea of the lawyer of the arrestee, that he's not going to be likely to commit another offense. Now, in order to safeguard all of these rights, which the Supreme Court has been saying it since many, many decades, the Supreme Court thought it fit that rather giving it a very vague flavor that only the person being arrested needs to be informed, it is but natural that he needs to be given all this in writing so he is able to make out his case, a foolproof case, in order to put it up into the best possible way of getting his bail. That's one reason. The second is that in any event, the officer is required to submit all of this to the adjudicating authority. Now, if these grounds are already in writing, there was no reason why the person who was getting arrested were not giving these grounds. So the Supreme Court said that these need to be given in order to uphold the sanctity of justice and to give an opportunity for the person to go and apply for bail.
Right. Mr. Raneena, do you think the Supreme Court has only upheld or clarified what the law already says, or they've read this into the statute?
So they have clarified the law because the law is very clear, and they have only said that the law must be upheld in letter and spirit. And therefore, they have made it very clear because, as was rightly pointed out by my colleague, in the past, different officers were adopting different stands. They were not complying with the law. They would just read out the charges, or they would just give them a vague idea of what the charges are. And this has to be put down. You cannot those who enforce the law cannot be above the law. They have to strictly follow the law of the land. And this is what the Supreme Court has now emphasized. Right. Every single officer in every part of India will have to obey the law of the land and make sure that it is complied in letter and spirit. And therefore, written summons or written explanation must be given, the cause for the arrest, what offense he has committed, what evidence they have in their possession. All that needs to be disclosed so that the arrestee can defend himself before the magistrate when he applies for bail.
Right. All right. Fareed Karachiwala, one very important case issue that came up before the Supreme Court, and the Supreme Court has ruled that this shows a lack of bona fide, and they referred to how the original ECIR in this case was registered in 2021. The accused was summoned in connection with this case. The accused sought anticipatory bail, and this was given to them till the next day. Then the accused were called the next day, summoned in connection with the old case, and that same day they were arrested in connection with a second FIR. So called on one pretext, arrested on another, all within a span of 24 hours. What does this show about the working of the Enforcement Directorate, and what would they have to change from here?
So the Supreme Court has made it in no uncertain terms. Paragraph 20 actually of the Supreme Court judgment makes it very clear that there needs to be a very high level of fairness because the authority and the power that the Enforcement Directorate has is very, very vast, and they need to exercise it fairly without any arbitrariness. There shouldn't be any colorable exercise of powers, and they need to be above board in respect of preventing any kind of miscarriage of justice, particularly because the powers which they exercise under the PMLA is, to that extent, if I may say so, a little draconian, where under Section 45, it is basically for the accused to prove himself that he's not guilty of the offense or that he's not going to commit any other offense. So to that extent, the Supreme Court has made it very clear that this exercise of power needs to be above board, needs to be fair. There shouldn't be any colorable exercise of power. There shouldn't be any vindictiveness, and the authorities need to actually act in a manner which would withhold or which would, show that the authority which is being exercised is without any real, damage which is done to personal liberties.
Mr. Raneena, do you feel that this entire judgment will make the working of the Enforcement Directorate, their approach to interrogating, summoning and arresting accused, more transparent?
I think so, and I think it needs to be so, because not only it has to be transparent, but it has to be fair, and everybody must be given an opportunity to be heard and to give his point of view. So if everything is in writing, then alone a person can deal with the issues. If something is just told to you orally, I mean, it can be very vague. But if something is in writing, you can pin down the Enforcement Directorate and find out what exactly is the ground for the arrest, or in what way the person has violated the law. and only then can a person defend himself in a court of law. Therefore, the important point is the written statement should be forwarded to the arrestee before any action is taken against him.
Right. And finally, why do you think this is important, Fareed Zakariwala? Because the court also said that if you do not give the grounds of arrest in writing, then the accused does not know why he's being arrested. And this can lead to a bit of confusion when the case is also before the court. Why do you think this is important, and why was it important for the Enforcement Directorate to do this?
So in the present case, which the Supreme Court has decided in the matter of Pankaj Bansal and Basant Bansal, the question was, Basant Bansal, who could not read English, was given, the grounds of his arrest orally in English. He could not understand English. He in fact, his plea in the Supreme Court was that he was never even told about it. The arresting officer made out a case that this was not only told to him in English, but it was also told to him in Hindi, and it was also told in the presence of witnesses who had signed the statement, which said that these grounds were made known. But when Basant Bansal, made his plea before the court, his plea was that this was never informed to him. Now, what the Supreme Court said, that if you look at the totality of things, if there are grounds which are there in writing, and if these grounds have to be submitted to the adjudicating authority in writing in a sealed envelope, then why isn't it being made known to the arrestee so that he knows what kind of a case he needs to deal with when he applies for bail? Under Section 45, it is for him to show that he's not guilty of an offense and that he's not going to commit any other offense.
Right.
Now, if these grounds are to be communicated to him clearly, he will be able to make a case in order to show as to what is it that he has done or has not done in order to secure bail. So the Supreme Court said that in the totality of things, it is but necessary, and there's no reason why these grounds shouldn't be given in writing.
All right. Thank you very much, Fareed Zakariwala, and also HP Renina for joining us on the program. Let's move on.